Good evening.
Good evening.
Oh, come on. I know it's raining. Enthusiasm. Yes. Hello. It's Monday.
It's raining and it's Monday and one enthusiasm. I love it.
Good afternoon.
Good evening, everyone.
Good evening. Krista, you got my email?
I did, ma'am, and responded promptly and not safely as I was driving.
Oh, okay.
The answer simply put is yes.
Okay. All right. Good.
All right.
So you'll call me with the rest of the information, or you sent me that already?
No, I'll call you.
Okay. Okay. That's
Yes,
fine.
ma'am.
Okay. All right. All right. So I know if you're like the staff to work today, they said they couldn't wait to get home to go and to take a bath and go to their bed and enjoy the rain. But you all aren't that lucky tonight. You all have me.
Sorry, I missed that. No class tonight?
I did not.
That's what I heard too.
I heard that too.
I said you all are not that lucky tonight. Not that lucky you have me. So we have any cases left over from last week? I think we do.
I know one at least we have is Cube.
Okay. Who's supposed to do Cube? Before I go and look in all my papers.
That's 2 parts. I'm trying to remember who's supposed to. I have the Court of Appeal part of it. I can't remember who's supposed to do the first part.
Yeah.
Check.
And Michelle was supposed to do the Supreme Court. So, but I think we only needed yours.
Why we only needed mine?
She wasn't ready. And she isn't on. Okay, I have that one and I have this one. Anyone read it?
Read which one was that?
This is Supreme Court. Scotiabank and Cube.
Let me see if I can message James because I know she said she did read it and she was ready. Let me see if she's having internet issues again.
All right, we'll wait for her. I know Krista's ready. And who had David? I think it was Miller. Miller, did you read David?
No, I didn't have it. I didn't say anything. I mean, I'm still trying to get home. I should be home in a few minutes, but I didn't see anything with David.
No, it's Chardine. PIB.
Pardon me?
It's the case David, Chardine, and First Caribbean International Bank.
Yeah, I didn't see that. I mean, if it's something I can do it quickly, give me a few minutes to get home. But yeah. I didn't see that one.
We're waiting. See. Wait, that's that. Then I assigned. Let's see. Cube. Who got cases? Because I'll have to go on my computer.
Yeah. James said she's trying to get back in. Her internet did go down, so she's coming on in a couple seconds, I guess.
Okay. Fountain, did I give you a case?
Yes, I have Damianos against PLB and the crew them.
Yeah, that's a good one. You know, Damianos, when they get their teeth and things, they don't let go.
Oh yeah, it was quite interesting.
Okay, so that one.
I also see Scotiabank versus Ricardo Gibson was assigned to Katora.
Yeah, she missed 2 classes. She never did that one. Is she on tonight? No. See. But that one was about inordinate and unexplained delays. That's what Ricardo was about. That's very short. That's only what, 6 pages. So that one wasn't too bad. And hold on. Who was supposed to do? Did we do? We didn't do Patakin. Commonwealth Bank and Patakin.
I don't recall that one.
Let me see. Damianos and BOB is Fountain. I have my list with you all. And then I have one that's I'll do Hughes Popal, Hughes Charles Popal and Roscoe Popal versus Kathleen Johnson Hassan. And then I have one Voice Caribbean and April Penn. I'll do those two. I don't think you got those. So I'll have to send those. Double check.
I'm searching my email and I don't see any of those two.
Okay, so these two I'll send you all.
I also see a case Miguel sent last week, Monday, Respect Our Homes, but I didn't see that assigned to anyone.
No, that was the Shanty Towns. We were finished with that. Remember?
Okay.
Yeah, that's Shanty Towns. That's what she called it. She called it that. I had assigned Patakin to somebody. And that wasn't too long. That was short. No pages. All right, so let's see. Should I start with one that I have?
Yes, that'd be nice.
All right. So this is Hughes Charles Popal and Roscoe Popal. They are the two plaintiffs. And they are suing Kathleen Johnson Hassan, trading as Johnson Hassan and Co. So in this case, Hugh is the first plaintiff, and his brother Roscoe is the second plaintiff. And there's Kathleen Johnson Hassan for damages. And the damages is due to the cost for their property and the building that they constructed on their property. So they're suing her for $129,000 cost. Now, Hassan is saying that she is an attorney and acted on behalf of Hugh in the purchase of the 3 lots in block number 56 in Nassau Village. Now, during the process of purchasing the properties, Hassan advised Hugh that the title of the lots number 9, 10, and 11 was good and marketable. It was later discovered that Hassan had failed in conducting her title searches, either to notice or to be alerted sufficiently enough to bring to Hugh's attention that the properties were subject to several court actions. And orders were made from those court actions, and that adversely affect the title of the 3 lots. So Hugh purchased the properties based on Hassan's opinion of title. So that would have happened around September 1988. Now in June 2004, Roscoe, Hugh's brother, he retained the services of Hassan to act on his behalf to convey the same lots that his brother had to him. So Roscoe said there was a retainer and an agreement was made between himself and Hassan in June 2004, and Hassan had agreed to represent him in the purchase of the property. And the brother, Roscoe, also paid Hassan for her professional services in advising him and also preparing the conveyance. He said that Hassan advised him that the title to the properties were good and marketable. So based upon that, Roscoe said he then decided to purchase the property from his brother, and he began construction. So the purchase between the two brothers happened on or about June 2004. And the conveyance from Hugh to Roscoe was dated the 16th of June 2004, and then Roscoe started building on the land. So now it comes that the two brothers, Roscoe and Hugh, discover that the title to the properties were defective. And they allege that Hassan had failed to notify Roscoe that Block 56, which is one of the number of the blocks of land subject to the Supreme Court order between Arawak Homes and John Sands. Hassan, according to the two brothers, had a duty to advise them of the said action and to warn them concerning the risk to the title and the adverse outcome of the action. So on the 29th of April, 2015, you hear the gap, right? 2004 was when the conveyance was done and they began construction. So now we're in 2015. Hassan maintained that reasonable care and skill was demonstrated when she conducted the business on behalf of Hugh, and she admitted that she did advise Hugh that there was a good and marketable title for those 3 lots. But she denied that she was negligent or that she was in breach of duty to Hugh in the course of conducting the title search. She maintained that in June 2004, Hugh instructed her to convey the lots to his brother by way of gift, and she also denied that she was retained by Roscoe, as he alleged. She further denied that she advised Roscoe, and again denies that she was negligent in her breach of her duty. So her defense is she's claiming that Hugh, being the first plaintiff, having disposed of his interest in the lots, because remember, he conveyed this to his brother, she said he has no legal right to bring an action. She also said that the alleged cause of action did not arise within the period for the statute of limitation, which is 6 years. So she went back and forth. She denied it. They claimed that it did happen. They said after the completion of the property transfer, Roscoe took possession of the lots. He began constructing a 2-story building. After the construction began, he was approached by the late Wilfred Coakley, who told him that the property belonged to Arawak Homes. He became immediately concerned, and then he contacted Mr. Hassan, who assured him that he had nothing to worry about and reiterated that the property was good and marketable. So he proceeded with construction on the land. So in order to complete the construction of the building, Roscoe applied for a mortgage from Scotiabank. The bank instructed the firm of Obie Ferguson and Co. to prepare the legal mortgage of the lots, subject to the deed of gift from his brother. O.B. Ferguson and Co. subsequently informed Roscoe and the bank that the title was defective. Hassan was contacted and they informed her. So Roscoe, Hassan, and Mr. O.B. Ferguson tried to pursue a resolution. And Hassan was amenable to amicably settling the same. However, they saying that she has failed and or refused to do so. And remember the grounds upon which she's saying she's refusing to do this because it's past the statute of limitation period to bring the matter before the court. So Arawak Home, the adjudged owner of the lots, have repossessed the same and demolished Roscoe's building thereon. Roscoe further believes that Hassan has breached her duty of care, owed both in contract and in tort, and that her failure to exercise reasonable skills to demonstrate professional competence has caused the second plaintiff loss and damage in the sum of $129,000, being the value of the construction. So the court decided that Hassan, yes, she was retained by Hugh first around August 1988 to represent him in the purchase of the 3 lots. That's a fact. The conveyance of the lots to Hugh was dated the 21st of September, 1998. Around June or July 2004, Hassan was instructed to prepare a deed of gift of the same lots from Hugh to Roscoe. Based on these instructions, she prepared the deed of gift. Hassan had advised Hugh that the title to the lots was good and marketable. Hassan denies that she ever advised Roscoe that his title was good and marketable. In fact, she denies that Roscoe was ever her client, was even a client. To the deed of gift from Hugh to Roscoe was dated the 28th of May, 2004. Roscoe discovered around May 2009 that Arawak Homes in fact owned the lots, which he had been given by deed of gift, and he had started construction. So that was already a 5-year gap. By an undated title search conducted sometime in 2008, it revealed that Block 56 is a part of the number of blocks in Nassau Village subject to Supreme Court order. And accordingly, based on this title search and a subsequent letter sent to Hugh's attorney by Hassan, which was dated the 12th of May, 2009, it was known that the title of the lots were actually vested in Arawak Homes and not either of Hugh or Roscoe. The title conveyed to Hugh was not good and marketable. Further, the same defective title was given by deed of gift to Roscoe. So the judge says, I must decide whether or not the cause of action which accrued to either party is statute barred by virtue of the Limitation Act. And if so, when did it become statute barred? So what the judge did is he went through then the period for the statute of limitation. He said, in order to do so, I must decide when the cause of action accrued. By virtue of the contract with Hugh and in accordance with the case of Foster versus Outred, it is well established that a cause of action, in fact, accrued when the actual damage was sustained. The damage would have occurred when Hugh purchased the 3 lots in reliance on his attorney's opinion on title and received his conveyance. The claim against Hassan can be brought both in contract and in tort. Because remember, tort, he can go in tort for negligence. As by virtue of the contract, with Hugh, Hassan owed him a duty of care. So how long then does the limitation period run? The cause of action, as pleaded in the statement of claim, relates to the advice given and the execution of the obligations arising from a contract of services between Hugh and Hassan. The cause of action does not arise for the conveyance itself, and accordingly, the limitation period is governed by Section 5, subsection 1 of the Limitation Act, and not Section 5, subsection 2. The limitation period of the cause of action accruing to Hugh would have expired in August of 2004 at the latest. So that means that Hugh's action against Hassan is statute barred, and of course, the judge struck it out. So the issue whether or not Roscoe was a client of Hassan so as to give rise to his cause of action, which is for breach of contract and tort against Hassan, is an issue in dispute also. And it could only be determined by hearing evidence and submissions on the matter, and it cannot be decided without the same. The judge says if it is decided that a duty is owed to Roscoe, the limitation period would expire 6 years from the date when the deed of gift was executed, based on her providing an opinion on title, which would have been 6 years from the 28th day of May, 2004, and would have expired before this action commenced. So the judge says, even if one were to accept that there was no knowledge sufficient of the wrongdoing to ground a cause of action in tort in May of 2004, the evidence agreed between the parties showed that knowledge was acquired in 2008. Remember, that's when Mr. Coakley informed him that the property belonged to Arawak Homes. And definitely by May 12, 2009, when Hassan wrote to counsel for Hugh to arrange a meeting to resolve the matter, Hugh and Roscoe. The cause of action would have expired as against Roscoe by May 2010 under Section 5(1) or Section 13 if there was insufficient knowledge in 2004. Time would run for 3 years from May 2009 to 2012, which was also before this action commenced. And so the judge decided that the cause of action of both Hugh and Roscoe was statute barred, and the action was dismissed. And Roscoe and Hugh had to pay attorney Kathleen Johnson Hassan all of her legal costs. Any comments?
I'm trying to figure out how come more of these attorneys don't be before the bar. This is crazy.
Wrong road. Good and marketable title.
Exactly. To think that she got away with that.
That is crazy.
I thought you all would love this one. Let me put a sticky here to send it.
That is crazy.
But this is a fact.
But she only lost based on the statute.
Yes.
On technicality.
Earlier. Yeah, they brought it earlier. They would have.
Right. And then as lay people, they don't even know that this is something that they needed to bring before the court. She's savvy enough to know.
In the middle of it, when the Arawak Homes, Bismarck Coakley came to them, they stopped and went back to her. And she told them, don't listen to what he's saying. Your title good. My Lord.
Wow.
So my question, Ms. Archer, could Roscoe and Hugh not negotiate with, since he already started construction on it, like negotiate to purchase it from Arawak Homes?
If you remember the ones
there was some negotiation.
This Arawak Holmes we're talking about.
Yeah. Yeah. Don't forget, we've done some cases already with negotiation.
Arawak Holmes, and he love it when you put one building on the things.
Bulldozer down.
Jesus.
To the ground.
My Lord, they do wrong to plenty of people. They're the pairs.
Yeah, people has been working too hard for their money for these people to be doing these things. I surprised. I know the murder rate high, but on the boy.
Miss Archer, sorry, my internet is continually giving me trouble. But I don't know, because you dipped out at one point. The thing it is, can they not still go after the lawyer though, who would have given them that good and marketable title? I mean, it's just a civil case on the side.
You mean sue her personally? That's what they were doing? That's what they were suing. Hugh and Roscoe were suing her.
Yeah, they were suing her.
The time expired.
Yeah, statutory law.
Yeah.
Oh.
But at any given time, I didn't hear she had a case with Roscoe. It was Hugh that she had the case with, right?
No, both of them.
When did she take up the case with Roscoe?
Both of them, when they brought them out of the court, it was Hugh and Roscoe.
Okay.
But the first thing the court said was that Hugh didn't have a leg to stand on because he didn't have any cause of action. He had already property to his brother.
Right.
Yeah, so he really shouldn't have been there.
Wow. After you build
Roscoe. Wow.
I don't know how they could live with themselves though.
Yeah, I mean, this man built his house, started to build his house.
That's what a minute, man.
And what did they say Arawak Holmes did? Bulldoze it down.
Yeah.
That's what I say, because I have my sister-in-law, apparently her mom died and her husband was living in the house too. It was all of them. And her mom died right here in Nassau Village in the back there. And her mom died. And when she died, the husband came to get the house. And apparently the house, she bought it and everything clear, but it was owned to Arawak Holmes. And that is the only way that her sister was able to get it from the husband.
It's 7 o'clock.
Because the Arawak Holmes owned it. He didn't know that. And she didn't have a clear title to it, but she had purchased his house and purchased his land. And no, she purchased the land and built a house. And Arawak Holmes came and said, you know, this is our land. And so that's why I asked about negotiation, because she went in to Arawak Holmes and they negotiated and she paid them for the land. And they, you know, because she had a whole house on it. And she paid for the house. I mean, she paid for the land. So that's why I was wondering if Roscoe couldn't go, since he already constructed a 2-story building, if he can just go and pay for the land.
Where his building is?
Who?
Roscoe.
He was building on these lots in Nassau
Village.
Oh, same place. Okay.
Yeah, lots 9 and 11.
That's what I was wondering why. And she was in a clean title. Why she let him continue to build?
Now the attorney who acted on behalf of Hugh and Roscoe was the attorney that Scotiabank had hired to prepare his mortgage.
Right.
So even he should have known that there was statute bar.
That's scary.
Miss Arch, I'm trying to figure out there wasn't an option. I guess we can't get into the mind of Arawak Holmes, but I'm wondering if it wasn't an option to just sell the property, since, you know, if you talk to the people who realize what has happened, as opposed to bulldozing, you know, the building. They couldn't just sell the property to them at that point.
They see the man pulled down.
That's what I was saying.
I know, but
even he's scared of God.
That's what I was saying, Stacey.
Just sell them the property and be like,
no. It appears that Arawak Holmes just like to send a message. You touch our line. It seems like their message is very strong, especially if someone already approached you about it and you continue.
Yeah,
that's what I'm saying.
Negotiation.
Yeah, but they only continued because of the attorney, you know, insisting, don't worry about it. You good. Exactly. So I'm going to go on the advice of my attorney.
That's what I'm saying.
But guess what? She's the one who told the court right off the top. that statute barred. So she knew that. She knew they didn't stand on.
Wow.
She dangerous.
We're not reading these cases to put labels. Let's think about good marketable
Okay, I retract it.
She's so dangerous. No, Stacey, she's dangerous. Don't get that one.
Title. You can talk about That's not nice at all.
Is it true though? It might not be nice, but is it true?
Yes, it is true. It is true. It is true. Okay, who ready to do Cube Supreme Court?
This is Michelle Lynn. That's my case.
Yes.
Okay, good evening to all. I'm going to summarize at best this case, because even Ms. Archer, the more these cases you give to us, I think I just get mad. And I'm right.
I want you to learn.
I learned, but I learned to get mad.
No, don't.
It ain't right. Anyways.
You're right.
This case in a nutshell is, and Ms. Archer, am I doing the Scotia versus them and then the appeal as well?
No, Krista's doing the appeal.
Okay. So in a nutshell, Scotia versus Cube. Cube W Enterprise Limited is the first defendant, and the estate of Warren Woodrow Wilson is the second defendant. Now, to understand that Cube W Enterprise Limited, Mr. Wilson was also the president of the company. And so this matter is being brought before the Honorable Justice Ian Winder. Scotia would have given a mortgage to Cube, with Mr. Wilson signing on as guarantor to the loan. So the mortgage was taken out, Cube, on the 24th of June, 2008, and guaranteed by Warren Woodrow Wilson, who was the owner and president of Cube. He guaranteed the mortgage by separate guarantee on June 23rd, 2008. Scotiabank commitment letter stated that a confirmation letter to Mr. Wilson noting a first demand legal mortgage for $224,000 was with the purpose to purchase owner-occupied. Sorry, Miss Archer, my glasses. The owner-occupied triplex at 5.8% prime plus 3.5%, which gave it really a variable rate of 9%. Non-refundable commitment fee of 2%, totaling $4,480, plus $75 for the application fee. Late fee of $20 to be applied if payments is not made within 5 days. So Mr. Wilson's monthly payment was $1,802.35. Prepayment attracted 90 days interest calculated on the full amount of the prepayment, a minimum of $500 up to 15% of the original mortgage is not subject to penalties, only that is if it exceeds the 15% of the original mortgage. So in a nutshell, Mr. Wilson died. When Mr. Wilson died, it was discovered that he had no life insurance over the loan. Now, the life insurance was a part of the necessary document needed to move forward with the loan. But Mr. Wilson would have signed to Scotia some forms to put this life insurance in place. The forms were incomplete, I guess, like in most cases, you know, when we're rushing, we won't follow the application, just let the people sign, right? But he would have signed these forms according to his wife, because here now the dead man can't speak. So the loan, because his loan payment was salary deducted. And then, so since he died, of course, there's no salary deduction to pay the loan. So the loan became delinquent. And once it was delinquent, Scotia then sent out its demand letter to repossess, because Mr. Wilson did not have a life insurance over the property, over the loan, that is.
Mm-hmm.
So
okay,
his wife and the estate
of
Mr. Wilson, on behalf of Cube Enterprise, is now appearing before the courts to say that that is not their fault that Mr. Wilson died.
I don't know if she could hear you.
That's all right. Let her go. Let her go ahead.
Okay.
Go ahead. She can hear us now? Oh, she dropped.
Her internet might have dropped. That's probably why she couldn't hear you.
Yeah. Oh, it was dropping.
Mm-hmm.
So while we wait for her to come back in, I want you to pay particular attention to clause 5G of the mortgage. So this is the clause that the bank is relying on with regard to the insurance. So that's on page, these pages are not numbered, paragraph 4. The borrower hereby covenant with the bank as follows. So she come in. Michelle Lee. You're trying to come.
Okay, it's back up again. You can hear me now?
We can hear you now. I just wanted you to emphasize before you get too far in, to read to them clause 5 of the mortgage deed with the covenant with regard to the insurance requirement.
Right, okay. Let me just get that back. Okay, let me get to 5.
That's in paragraph 4. That's the 1, 2, 3, 4th page at the bottom. Clause 5G of the mortgage provides the borrower hereby covenant the bank as follows. You see it? But she dropped again. Okay, so let's go back. Okay. So the covenant says that during the continuance of this security, the borrowers will, at their own expense, keep in effect with such insurers as the bank may select, a mortgage redemption policy on their life for an amount equal to the reducing balance of the principal during the mortgage period, and will assign the benefit of the said policy to the bank, and also will deliver to the bank said policy and the receipt for any premium payable in respect thereof. Michelle.
Yes, ma'am. Thank you so much. Going out again. All right. So thanks, Ms. Archer. And so we'll deliver to the bank the said policy and the receipt for any premium payable in respect thereof. If any such life policy as aforesaid shall become voidable or void, the borrowers will forthwith do all things necessary for keeping the same on foot if voidable, or if the same shall become void for effecting a new policy for a like sum to that assured by such void policy and for assigning the new policy to the bank. So in a nutshell, with that piece, that he was supposed to have the life insurance in place, should the life insurance, I suppose, become void, he's supposed to get new life insurance and then assign that as well to the bank. So if the fault should be made to the borrowers in regard to their obligation in respect of life insurance hereunder, it shall be lawful for the bank to fulfill such an obligation, whether by effecting a policy or paying a premium or otherwise, and any money expended by the bank in relation to any such fulfillment shall be deemed to be added to the principal and shall bear interest and be secured and payable accordingly. So that every life policy affected hereunder and all monies to be received by the bank thereunder shall be held by the bank by way of collateral security for the payment of the principal and subject thereto in trust for the borrowers. So likewise, you know how when they make their assignment, if they are unable to make their premium payments, then the bank then will go in and make those premium payments and debit the principal of the loan to cover such. All right. But in Mr. Wills, okay, so let me just read this piece real quick. 12, yes. Of the mortgage provides that the statutory power of sale shall be exercisable at any time after the money owing on the security shall have become payable after 21 days. The agreed monthly mortgage payment was $1,802.35. The last payment on the mortgage was the 30th of January 2017 in the sum of $1,689.49. Wilson died on the 17th of January 2017. On the 27th, 2017, letters of administration was issued by the Supreme Court to Laverne Wilson. That's Wilson's lawful widow. So he died on the 17th, and they would have sent her a letter on the 27th of, he died on the 17th of January, and they would have sent her a letter on the 27th of November.
4th of May.
Pardon me?
No, he died on the 17th of January, 2017.
Yeah, and they petitioned the court on the 27th of November.
Her letters of administration are her probate papers.
On the 27th of November, letters of administration was issued by the Supreme Court to Ms. Wilson.
Right, so that's her probate papers.
Okay.
Yeah.
Okay. So by the letter dated the 4th of May, yes, you're correct, by the branch manager wrote to the attorneys for Wilson's estate. So they referred to the subject of the letter dated the 27th of March. Please note that the subject mortgage does not have an insurance policy attached. Life insurance is an optional feature, which is solely the responsibility of the customer. By the letter dated the 11th of June, 2018, the bank's legal director wrote to the attorneys for Wilson's estate in the following terms. Our branch, in the review of Mr. Wilson's, that's the deceased file, has determined that the insurance was not taken out. Hello?
Somebody need to mute.
Oh. So the bank writes, our branch in review of Mr. Wilson's file has determined that the insurance was not taken out. Additionally, on review of the monthly statement, it has been determined that no payments were taken out for insurance. And so the total balance on the loan to date is, now remember he borrowed $224,000, but the total loan on to date is $225,360.33 with premium, with per diem, of $43.27. The bank says that it was a responsibility, of Mr. Wilson to complete and provide to the bank a copy of his personal life insurance policy, naming the bank as beneficiary. This assignment of Mr. Wilson's personal life insurance, the bank says, was not a requirement for the loan to be finalized and funds disbursed. Mr. Wilson, they say, failed to assign his personal life insurance policy to the bank. So in a nutshell, when the wife and the estate would have thought that the bank should have been responsible because Mr. Wilson would have signed some papers, but not, and would have argued that they should not have dispersed any of the funds to Mr. Wilson if the life insurance was not confirmed as being in place. And so the bank in its defense would have said that no, the life insurance was not the only requirement. They could have dispersed the loan, but it was Mr. Wilson's responsibility to ensure that he had his life insurance in place and not the bank. All right, so when we would have gone down, the evidence of Laverne Wilson in her first affidavit provided that I have read the affidavit, and on the 24th of June 2008 for the sum of $224,000, for which my late husband Warren Woodrow Wilson, as the second offender, stood as guarantor. I accept and agree that the granting and disbursement of the said mortgage was subject to the terms of the facility letter being fulfilled. The facility letter called for my late husband to have life insurance coverage in the event of his passing during the life of the mortgage. As far as I am aware, my husband did all that he was required to do for the insurance and mortgage payments to be taken out by way of salary deduction to his account, over which the plaintiff had full control, meaning that the bank had full control to take out of Mr. Wilson's account to make payments. She says too, I knew that this could not possibly be true, as my late husband had told me that, and it's underlined there, as my late husband had told me that he completed and signed the necessary insurance document provided to him by the bank for their in-house coverage and turned it over to them for submission to their in-house carriers. When we inquire about the in-house insurance, they said that they were not aware of the same and referred us to the Oakesfield branch where my husband's loan file was actually located. Since the plaintiff at all times controlled the second defendant's bank account in which his salary deposits were made, it was always open to the plaintiff to apply insurance premium therefrom to ensure its own protection as for the facility letter and the assignment form. She said that my late husband and I always believed that proper coverage was in place because the plaintiff was to submit the assigned form to its carrier. In this case, the plaintiff had a duty to protect both my late husband's interests as well as his own by ensuring everything was in place and should be stopped from claiming otherwise. So in the evidence of Laverne Wilson in her supplemental affidavit, she said that I cannot help but observe that at page 8 paragraph, and she made note of it, that every life insurance policy effect hereunder and all monies to be received by the bank thereunder shall be held by the bank by way of collateral security for the payment of the principal and subject thereon and trust for the borrowers. So in this case, then, the statement of Mr. Aubrey that the insurance policy was not the central security for the loan is not totally accurate, but was a collateral security which the bank would hold in trust for the stated borrower. So the plaintiff bank failed in its responsibility to protect the interests of all parties by ensuring that the subject life insurance was duly assigned, as there is no question that my late husband had signed the relevant form and expected the bank to convey the same to its selected insurer. In this regard, the bank should be stopped by reason of its own culpability and failure from further action in this matter. And so I just want to, in a nutshell, say that all of this was because Mr. Wilson had died. The bank had promised to according to her, again, it was just a hearsay, that the husband said that the bank was supposed to have done that. And so the courts then would have awarded Scotia the claim to repossess the house because nobody was paying the bill and it was time to have it repossessed. There was no life insurance and the house still remains, the triplex, sorry, still remains the security over the loan.
Mm-hmm. Remember, she said she was specifically told that she couldn't pay anything until the probate was completed.
Right.
As she wasn't named on the mortgage.
Right. Sorry, I left that piece out. So she was told that because she was not, they didn't even want to give her really any information because she was not named on the mortgage and they had to wait for the probate to be completed.
Mm-hmm. So the bank just followed the steps under the Homeowners Protection Act.
Right.
Excuse me, which case is this, please?
This is Cube.
Scotiabank
versus Cube.
The Supreme Court.
I can't seem to find it.
It's I only would have sent it out. To the top of it, it has, well, in the matter property, whatever, but Scotiabank Limited and Cube W Enterprise Limited and the estate of Warren Woodrow Wilson.
So the court relied on clause 5G of the mortgage.
Right, that the borrowers, that during the continuance of their security, the borrower would at his own expense keep in effect the insurance. And that it was his responsibility to ensure that his life insurance was paid to date. Likewise, you know, we say to people all the time, sometimes the bank even make error, but you must check up on your policies and you have to make sure, and with the bank too, you know, we want to ensure that every year they make sure that those policies are paid current. And also clause G would have stated that if the insurance would have defaulted or lapsed, that it was his responsibility to put in place a new insurance and have that new insurance also assigned to the bank.
Yeah.
Because sometimes students, Archer, not taking off of the subject, because people will cancel their insurance policies, which they have the rights to do, or not pay the insurance policy and go someplace else and get a new policy, even with the home insurance. And then the bank isn't assigned as the lost payee of those insurances. And then they want the bank to know that they moved their insurance. Mind you, they didn't come in and say anything, but they want the bank to know. I mean, you know, without informing the bank, they think the bank should know they moved their insurance.
Yeah, so this was the judge. The judge said there's no evidence that Wilson did anything relative to applying for any in-house insurance with the bank. An incomplete assignment form is not an application for insurance. No application forms applying for insurance was completed by Wilson. Wilson was a custom officer and a businessman. The principal of Cube W, an incorporated company which owned an apartment building. Wilson has to be credited with some knowledge of business affairs. He must have known that he did not apply for insurance, having not signed any insurance application forms, which are notoriously extensive with medical and lifestyle questions. Other than the assignment, there's no evidence that he completed any medical forms or underwent any medical examinations, if needed. In addition to knowing that he did not apply for insurance coverage specifically for the mortgage, more importantly, Wilson would have known that he made no payment for any insurance policy over the 9 years he serviced the loan prior to his death. Wilson knew he wasn't being assessed for any insurance premium in the facility letter. So whilst the bank may have overlooked this issue, Wilson certainly knew he wasn't covered by any insurance for which he was paying. So the court recognized it based upon everything what the wife said, and then looking at what he did during the tenure of the mortgage while he was living, that he knew he didn't have it. But the court also said that they accept that during the life of the mortgage, the bank ought to have picked up on the failure of Wilson.
Right.
But he said that no red flags were raised. So that means that's a gap in the bank's procedures.
But that was not the main purpose.
No.
Yeah. That was not cited as one of the main purposes for the disbursement of the funds. The fact is that the bank dispersed the funds, the property belongs to the bank, and it is the bank's. And he just wanted to say too that, and having regard all of this, it is clear that there was no duty of care by the bank in favor of the defendants concerning the obligation to assign Mr. Wilson's personal life insurance to the bank. The failure is that of the defendants, and the loss is to the bank and not the defendants.
Mm-hmm.
Yeah, so any failure of the bank to appreciate that no insurance policy has been assigned to it has no clause, no cost loss to itself. And so that the bank, in this circumstances, he gave judgment for the bank for the sums due under the mortgage and for vacant possession, because it is the bank's property.
But that must have been very hard for that wife.
But to consider she came in and wanted to make the payments, but again, it's not her thing.
Lesson learned. Her name wasn't on the mortgage.
Yeah, her name wasn't on the
mortgage. Make sure, and that's a lesson right within itself.
Yeah. Mm-hmm.
But a further lesson is to make sure check up on stuff.
My Lord.
She couldn't check up on it because it wasn't in her name.
No, I meant in terms of his life insurance.
The information seems to have been limited.
In a situation like that, whose responsibility is it to ensure that the loan payments and everything are being made? Where was the executor of the estate?
No.
Loan administration does that. That should have been the bank loan administration department.
That's what I'm saying, because I wonder who checked that file back.
Yes, they normally do that.
And say that the collateral wasn't in place.
Call.
But remember
yeah, they want to check that file back. Yeah. And look how much time has passed.
Mm-hmm.
Yeah, but remember now, her name was
don't forget.
No. So I ain't talking about her. I'm just talking about the bank's part.
I'm talking about the bank on the whole.
Oh.
With insurance not being paid.
No, I'm talking about, Ms. Archer, I'm talking about from the point of view of the company that Cube, that Mr. Wilson was the beneficial owner of. So thinking about, okay, who in that instance would have been looking out for the best interest of the estate?
No, remember. Don't forget.
Sorry, one at a time.
Okay.
Which is being paid the salary deduction. And so I'm talking from the bank.
Go ahead. You're going in and out though.
I too was talking from the bank's perspective as to who was checking the security part of it to make sure that he would have done the life insurance, to ensure that at least he should have provided life insurance.
But I think Krista was asking from another perspective. Once he passed away, she was asking for the executor of the estate once he passed away, knowing that the salary deduction would have stopped.
Right.
Steps were taken.
I'm thinking there's a family business with him being the principal. I mean, the thing as to why the wife is in front.
Okay, so the company itself, Cube, he was the beneficial, right? And he was president.
Oh, no.
Now, if he had appointed his wife as a director of the company, then she could have continued to act as the director. But apparently she was not on the documents. That's how it appears.
Of Cube's document.
Did he die intestate though?
He died intestate, which means that
right,
she could not do anything until she had those letters of administration.
Oh, okay. I missed the intestate part. Okay, because you get me asking, where's the executor of the estate? I'm like, what? Okay.
What year was it that he passed away? 2017?
2017. He got the mortgage in 2008.
No, I'm trying to figure out. I know that the Homeowners Protection Act came out in 2017. I'm wondering which month, because under the Homeowners Protection Act, anyone living in the home, whether or not they're on the mortgage, they can apply to the court for relief, where the bank has to give them the opportunity to write any default in the mortgage. So I was wondering if the wife would then, even though she wasn't on the original mortgage, if she'd be in, but I see where the court did suspend judgment to give her 6 months to try to negotiate something before they were able to go through vacant possession. So maybe they, well, Krista has another part, I guess, the appeal.
Yeah, Krista's the appeal.
Yeah, it doesn't speak to that though, Ms. Knowles.
Okay, thanks.
Okay, go ahead, Krista. Yeah, go.
Okay. So Cuban.
Yeah.
Okay, great.
Cuban, the estate now appeal the judgment. Now there are 6 grounds of appeal that they're bringing before the Court of Appeal. They summarize them and consider them each individually. Ground number 1. So the appellant, which in this case will be the estate again, their primary ground is that there was an obligation on the part of the bank to provide life insurance on Mr. Wilson. And this is referring to paragraph 24 as a prerequisite for providing the loan. However, in paragraph 24, the trial judge said, having considered the evidence of the witness, I did not find as a fact that the bank was to provide insurance or that Wilson understood that insurance was in place to secure the loan. Other than the wife's testimony, which Michelle has already shared with us, and they just saw that as uncorroborated evidence, there is nothing to indicate that any house insurance was being offered or taken out by Wilson. On the other hand, the evidence of the defendant's witness, Mr. Duncombe, who witnessed the execution of the insurance assignment form, was that there were 3 copies of the form executed by Wilson. 1 copy was for the bank's file. 2 was for Wilson to take to his private insurers to complete and return, confirming that the policy had been assigned. Now, of course, this contradicts Mrs. Wilson's testimony that they were going to be using the bank's in-house insurers. So going on, it says there was no requirement to take out a new policy, as Wilson may have had an existing policy which could have been assigned. However, he did not return to the bank with any executed forms. Ultimately, whilst the bank, to its detriment, issued the loan proceeds, no assignment was made in its favor. There is no evidence that Wilson did anything relative to applying for any in-house insurance with the bank. An incomplete assignment form, again, as Ms. Archer said, is not an application for insurance. More importantly, Wilson would have had to have known, again, that he made no payment for any insurance policy over the 9 years he serviced the loan prior to his death. So on this point, the Court of Appeal said on a proper reading of the facility letter of May 2008, the bank was entitled to refuse the advance of the loan it had agreed to make unless Wilson provided insurance. So it was entitled to refuse. However, there was nothing to prevent the bank from making the loan without the life insurance policy. It was a requirement of the bank, not the borrowers. So by issuing the loan without the insurance policy as a security, not necessarily as a requirement, as in a box that you have to check off, it did so at its own risk, and the borrower could not complain if the bank loaned them the money without the insurance being paid. So we agreed that with the trial judge, when he found in paragraph 25 that it was the obligation of Mr. Wilson to provide a life insurance policy which was assigned to the bank. The appellant's reliance on clause 5G of the mortgage is misplaced. That clause is in the following term. Borrowers hereby covenant with the bank as follows, that during the continuance of this security, the borrowers will at their own expense keep in effect with such insurers as the bank may select a mortgage redemption policy on their life for an amount equal to the reducing balance of the principal. Again, this was stated in the original case. That clause enables the bank to take out a life insurance policy, but does not require it to do so. The appellants had no reason to believe that the bank had in fact taken out any insurance policy, as there was no evidence of same.
No, but Krista just said, the clause 5G, the covenant for the insurance. It says that the clause enables the bank to take out life insurance, but it doesn't require the bank to do so.
Yes. Mrs. Wilson's testimony is of very little value. Judge the court, she was not present when the loan was negotiated. Therefore, ground 1 has no merit. Ground number 2, the appellants are stating that the learned judge erred in law and in fact, and or wrongly exercised his discretion by failing to find that the proper execution of the general security of the life insurance, as indicated in the facility letter, was a condition precedent of the contract, which was mandatory for the exercise of distribution of funds. Essentially, what they're saying is that they're claiming that the judge made an error in stating that the life insurance was not mandatory, as we just stated just now. So the Court of Appeal, it is in our judgment simply misleading to say that the provision of life insurance policy was a condition precedent to the making of the loan. The provision of the life insurance policy was to be a part of the security to be provided by the borrower, not a condition precedent to making the loan. It was a condition that the bank could waive. There was nothing in the facility letter which prevented the bank from advancing the loan without all of the security being in place. This was a risk that the bank could take. Again, ground number 2 failed. Ground 3, that the learned judge erred in law and in fact, and or wrongly exercised his discretion where his determination in paragraph 25 of the judgment, which we reviewed earlier, were inconclusive, inherently contradictory, and inconsistent with the presented evidence and witness testimony, rendering his conclusions unsafe. So this criticism, the Court of Appeal said, is without merit. As pointed out earlier, the obligation to provide the life insurance policy was that of Mr. Wilson. Moreover, even if the bank was jointly responsible to ensuring that a life insurance policy was in place, which it was not, that would not relieve Cube of its obligation to repay the loan or the bank of its right to enforce a security created by the mortgage over the property. At best, it could only relieve the estate of Mr. Wilson of its obligation under the guarantee, because remember, the actual borrower in the mortgage was the company, not Mr. Wilson himself. He only guaranteed it. So ground number 3 as well could not succeed. Ground 4, the learned judge erred in law and in fact and or wrongly exercised his discretion in making the determination, this time in paragraph 28 of the judgment, that an irrevocable, thank you. I don't know why I was tripping on that. An irrevocable appointment is a donor-donee relationship that differentiates from an attorney-client relationship, whereby the judge implies there is no duty owed between a donor-donee relationship. The judge further errs in negating, impliedly and with no evidence, the contention of the appellant that the relationship was subject to a duty of care. So this is, and I will read clause 14, a reference to where the bank was said to stand as the attorney of the borrowers. So clause 14 says, the borrowers hereby irrevocably appoint the manager for the time being of the bank to be the attorney of the borrowers for the borrowers, and in their names and on their behalf, and as their acts and deeds to execute and complete any assurance agreement, act, or action which may be required or deemed proper for any of the purposes of these presents. So the Court of Appeal, this clause authorizes the bank to act on behalf of the borrower to affect things that the borrower is required to under the mortgage. It does not oblige the bank to act on behalf of the borrower, nor does it impose any duty on the bank to act on behalf of the borrower. It is an unrealistic position for a borrower to say, and this one is a tongue twister, I did not do what I was supposed to do, but you can't enforce your security or require me to repay the loan because you did not do for me what I did not do, because you could have done what I did not do. I will read that one more time for entertainment purposes. It is unrealistic for the borrower to say, I did not do what I was supposed to do, but you can't enforce your security or require me to repay the loan because you did not do for me what I did not do, because you could have done what I did not do. Suffice it to say, this ground also failed. Ground number 5. The view of the judge in paragraph 30 of the judgment is inherently wrong in law and in reason. All the elements of contractual estoppel do exist between the appellant and respondent. Court of Appeal said that this defense based upon an estoppel is difficult to understand. It's a head scratcher. It seems that the appellants are alleging that the bank represented to them that it had taken out a life insurance policy and that the appellants relied upon that representation by not taking out any insurance policy themselves.
But isn't the man dead?
And ain't no insurance payout, right? Yep, he dead. But there is no evidence that that representation was ever made. And it is contradicted, in fact, by the evidence, again, of Mr. Duncombe. He was the defendant's witness. Mr. Duncombe said, to the best of my knowledge, and as was our practice, I would have printed and executed, again, 3 copies of the assignment letter, 1 for our files, the other 2 given to Wilson to take to his insurance company. He was expected to return to the bank with one of them stamped by the insurance company. Again, remember, he never did. The customer would have had to sign to accept the facility letter, which would outline all the terms of credit. So the Court of Appeal, the appellants could not believe that any life insurance policy was taken out, as there was no evidence, once again, that any premium was ever paid by them, the appellants, or by the bank on their behalf. Simply put, the obligation was that of the borrower, and he failed to do so or ensure that it was done. That ground failed. Ground number 6, which is our last one. The learned judge was wrong in fact and in law by attributing full responsibility for the failure of implementing the life insurance security upon the appellants. The Court of Appeal states this ground based in negligence is misconceived. The assertion is that the bank had a duty of care to the borrowers to ensure that the borrower did what the borrower was supposed to do. That is to say, the bank had an obligation to ensure that the customer provided an assigned life insurance policy, which was the obligation of the customer to provide. I do not accept that such a duty of care exists. In the circumstances, this appeal must be dismissed and the judgment of the trial judge is affirmed.
Anyone
to the successful party, the end.
Anyone could give me any idea why that provision in clause 5G for the insurance requirement is written that way? Where the onus is on the borrower to ensure that he has life insurance? Think about it.
Miss Archer, that's the same thing I'm saying. You gotta make sure you have the life insurance, especially when it comes to your family. Should something happen to you, make sure that's in place so that can be taken care of. Because I know her, she would have been thinking, you know, okay, he dead now, so I know he got life insurance on this thing. Nah, this whole triplex is mine. I owe no bank.
Exactly. And then
There must be something legally why they can't force them to do it. Have to be some legal reason why the bank can't force you to do your insurance, or they leave it to the borrower.
They leave it to the borrower
The
because
security, the building is the bank's.
the building belongs to the bank.
Then look up your family, that's still mine.
They have have their collateral. They have that building.
That's right.
You don't get your life insurance and you die. They sell it. They still get their money.
They still get what they do. Yeah.
They only just want their money. So if it's your life insurance, let's say for example, too, the life insurance could have lapsed. So that in this case again, you know,
on you.
It's on you.
Yeah.
The building is mine. That's what I'm interested in.
Yeah. And he should have made provision to cover himself and his family. But he didn't do.
But and so too what the judge would have pointed out, he knew that wasn't even coming out of his salary. So who's paying it?
Don't know.
Only his principal and interest was coming out of his salary. So who's paying for your life insurance and your home insurance?
Don't know. But you know, I thought about this when I read it. If he was going to divorce her.
Oh, really?
No, I'm saying.
Oh, you're reading into it.
Yes. He already put it in a company.
Oh my God. And she naming on it.
Yeah, some level of distrust was there though, because she was in, like you said, she was on the company and he didn't have on the market. So there's some level where he didn't understand something.
Wow. The person who would have asked about the case when it was sent, I saw it. It's Miguel would have sent it March 13 at 5:48. So just in case if you still have it in your inbox.
I still can't believe he died intestate. Like you said, he was a businessman. How could you not? How could you not have a will? You own things.
You see.
But see, that's the same thing the court was saying. This is a businessman. Well, how you know you don't get no life insurance? How you know you're placing insured at all?
He knew.
But I with you, Masacha then.
He thought he was pulling a fast one by avoiding it, having the insurance premiums deducted as well.
He was contemplating in the event something happened, who he was leaving his things to, and it definitely wasn't her.
Well, his untimely demise, it sure went left.
No, it went right just where he wanted to go, because he don't want her with it. That's it.
Yeah.
Good.
So, and she, I guess, depends on a good and a good marketable amount. Depends. She may get something. She may not get anything. You know, as good reason from the dead.
And bury him again.
I'll dig him up. But Masacha, what I could not get is after the 9 years of making salary deductions, obviously he wasn't delinquent, well, I guess, which would not have raised too much of a flag to the bank. But he borrowed $224,000, and after 9 years of paying, he owed them $225,000. I couldn't get.
I saw that too. Yep.
How so much?
He used to get cremated, Jack.
Pine box in a hole.
Plastic bag on the side of the road.
Oh man! Oh no!
Burn up, light the fire.
But you could imagine that poor wife.
I know, right?
After she would have gone through waiting all of those months to get her letters of administration, march back up to the bank and find out, okay, there is no life insurance.
Wow.
It's hard. It's hard.
That's what I imagine, since he was a big businessman. She probably had a big funeral for him.
Yeah, she had a big funeral. I was gonna dig him up and have a second funeral, and he's getting cremated.
The thing, didn't she? Somebody had to pay for the whole probate process as well.
That's all.
Because she thought she was getting something. She thought she was straight.
She had to pay for the probate. She had to pay for the first time they went to court, and she had to pay for the appeal, eh?
Yeah. She had to pay for the funeral.
And lost all of those.
All in the hopes that she win, that she would get that triplex and the business and everything else that goes with it.
My Lord.
Poor child.
Yeah. The property was in Venice Bay.
And the thing is, it sounds like, I mean, it sounds like he really didn't have that much else other than this, because they went back to the Court of Appeal with no new evidence or anything else, just restating the same facts over again.
Yeah. It was a triplex.
We trying hard.
So
yeah, you make me go check all my documents second time.
Fountain, you're very quiet. From a male perspective, what did you?
Say again, I didn't hear you.
I said, from a male perspective, what are your views? All the female bashing this poor dead man.
Yeah, I hear plenty man bashing going on, but I don't really have I don't have a lot of views on the man in terms of what the man was doing, what he was planning. I can't infer, I can't guess. I don't know if he was planning to leave, if he was planning to run. I don't know what the man was interested in doing. I believe he was a good businessman, but he just was reckless in this instance, because I don't have no other evidence to suggest he was reckless otherwise. All I know is in this instance, for sure, he was reckless. He did not take the steps necessary. And the wife did. Because he didn't even. He really didn't even try in this instance. The wife did her best and endeavor best to fight for what was hers, but it just really didn't pan out, and it's unfortunate, but that's just the law. At the end of the day, I don't know what he was trying to do, planning to do, but may he rest in peace.
Mr. Fountain was a part of that Court of Appeal judgment. Y'all didn't hear just now how well put his summary on that was, and his determination. I loved it.
Yeah. So this unit, module 8, because I know you've read it. If you haven't read it, read it. But what I like to do is just what we just did. Look at clauses that are in the deed to see how the court interprets it and what's the result afterwards. Because the mortgage deed depends on the institution. The wording will more or less be the same. But what does it really mean when something happens? That's the key to most of this. What does it mean? Okay, Fountain, let me put it over to you now. Read your case.
All right, well, my case was, in similar respects, something that really fell on interpretation of clauses within the agreement, but it went as such. It really was the case of Damianos, George Damianos, who was the principal of Damianos Southeast International Realty against BOB Limited, the beloved bank of most of my classmates here, Windermere Island North Development, Joseph Carey Rich, and CH Windermere Lending LLC. BOB, Windermere, Joseph Carey, and CH were all, they were different defendants, but they were all named in this case. But the interesting thing is that they each had their own attorneys representing them. And this was before Senior Justice Indra Charles. The issue here really was that this was a matter of whether or not Mr. Damianos and his company was entitled to commissions on what he determined was a sale of property, which he was the exclusive listing agent for. Also, Mr. Damianos had some allegations of conspiracy between the second, third, and fourth defendants to tortiously interfere with the listing agreement that was held between Mr. Damianos and the bank regarding the property. Also, he held that there were allegations of a conspiracy to injure Mr. Damianos tortuously as well by unlawful means. And for these grievances, Mr. Damianos claimed that he was due to commission for the sale of the land in question and damages for the injuries perpetrated against them. So these are some of the facts of the matter before you really even get to the issues. In 2003, the bank advanced a loan to Wind, which was the second defendant, as a developer. And this was secured by a debenture and a first demand legal mortgage over the property. Wind later defaulted on the loan due to facing financial difficulties, and the bank was entitled to exercise its power of sale. The bank then engaged Mr. Damianos as a real estate agent to market and sell the property in 2016 by way of entering into a listing agreement. Now, the listing agreement was not in perpetuity, but once it expired, it would roll over until invalidated by the bank. And the listing agreement gave Damianos the sole and exclusive right to sell them and market the property, and entitled them to a 6% commission of the property for its sale. Keep in mind that the property was listed at US $15.5 million. Damianos then began to market the property. On the 29th of June in 2016, Mr. Rich toured the property with Mr. Damianos and this group called the Noteware Group as interested purchasers. On July 3rd, 2016, Mr. Rich sent an email to Damianos and Noteware about the transaction, but nothing happened from there on out. On the 25th of January 2017, the bank was provided with an offer from the Bronstein Group to purchase the property at US $6.5 million, which the bank then counter offered at US $7.6 million but nothing moved forward, and Damianos was actually given some updates about this via email. On the 15th of March in 2017, the Bronstein Group offered a gross offer to purchase the property at US $7,325,000. 5 days later, on the 20th of March 2017, Wind and Cross Harbor, which is a different group, informed the bank that Wind was interested in settling its liability, which is the mortgage, and that Windermere, CH Windermere, who was the fourth defendant, would be the source of funds to refinance the debt. On the 5th of April 2017, Wind and CH Windermere gave letters to the bank regarding payment of the loan in full. On the 23rd of May 2017, Damianos was informed that Mr. Rich and his backers were going to repay the debt in full as per their plans. Just for your information, that Mr. Rich was a part of the Wind and the CH group here. He is also the person who was with Mr. Damianos, who went to tour the group with the Noteware Group. So the bank also said after the 23rd of May that should this fail, they will re-engage with the Bronstein Group. On the 22nd of September 2017, a loan sale agreement was entered into between the bank and CH Windermere to pay the loan in full at the amount of US $7.2 million. On the 12th of October 2017, Mr. Benedy, who was from the bank, advised Damianos that Wind was paying the loan back in full. On the 6th of March 2018, the bank and CH Windermere entered into the loan sale agreement and a deed of transfer of debenture and first legal mortgage and supplemental debenture and assignment of guarantee was all executed. And finally, subsequent to these actions, Mr. Damianos made a demand for his commissions, to which he was told, no, he is not going to receive any. So what's the real issues in this matter and what really brought this before the court? The issues here really came up as to, number one, whether the transaction between the bank and CH Windermere constituted a sale of the property for the purposes of the listing agreement. If the answer to that is yes, would Mr. Damianos be entitled to 6% commission or damages against the bank for breach of the listing agreement? If the answer to 1 and 2 were yes, would Damianos be entitled to additional damages as a result of the collusion that he was actually out there purporting? Another issue was, did Wynn and Mr. C and Mr. Rich and or CH jointly conspire to result in tortious interference with the listing agreement between the bank and Mr. Damianos? And if the answer to 3 and 4 above are yes, is Mr. Damianos entitled to additional damages against Wynn or Mr. Rich or CH for tortiously interfering with the listing agreement between the bank and Mr. Damianos? And if so, what is the measure of the damages? Now, what the court did in this case was they took this issue apart piece by piece, again, as I listed in the issues there. And the first real issue that they really looked at was the transaction between the bank and CH Windermere, a sale of the property. Now, to complete this, they started by, number one, looking at the words in the agreement and using case law and various statute law to essentially establish that words should be given their plain meaning when it's two business parties conducting business with each other. And they examined the clauses of the listing agreement as well as case law, as well as they looked at different statutes to determine whether or not what transpired was a sale, and did the actual listing agreement include any type of transactions other than a sale. And in conclusion, in all of this, one of the attorneys, which is the attorney for the bank, I forget which case they brought forward, but they leaned on a case which allowed them to determine that this was actually a transfer, not a sale of the property. This was simply a transfer of the mortgage. It was, what's the attorney name? Maury, who actually presented the case of Simpson, where they determined that this was actually a sale of the mortgage and not the sale of the actual property in and of itself. Which the additional attorney, I forget who was the representative, I think for Mr. Rich, their attorney also used the same case, basically presented the same information, and Justice Charles agreed that it was actually a sale of the mortgage and not a sale of the property. So with issue one failing, issue two automatically failed. If he couldn't produce enough evidence to show that it was actually a sale of the property, then he would not be, he's not therefore entitled to the 6% commission. And he wanted the commission on the 7.2 million, which was 432,000. So he lost on that ground. The second bit's really in terms of the tortious interference between the banks and otherwise, the teams for the other defendants, they simply put Mr. Damianos to strict proof, to prove that they indeed were conspiring against him and they were intending to injure him and tortiously interfere with him and basically keep him from gaining his commissions and not allow him to actually benefit from the sale of this property. The reason for actually taking on that particular defense or that strategy was because of the allegations he made. It is a very, very serious allegation, and an allegation as such of that nature must be proven to the highest standard, and the burden of proof is actually on Mr. Damianos to really show that you have been injured and interfered with, or there's a conspiracy to do these things lawful and or unlawfully. And it was found in the case that Mr. Damianos was unable to do so, unable to prove the conspiracy or the injuries that he so claimed in any means, whether unlawful or lawful. The courts actually laid out cases whereby the claims on these grounds are actually to be laid out, the elements and the limbs of the claims, and it was simply stated that in the further and better particulars, as well as other petitions that were actually brought forward by Mr. Damianos. He had no grounds or no evidence laid out and was simply asking the court to merely infer and look into the transactions of what actually happened and what transpired, such as Mr. Rich touring with another company and then coming back and in the background making arrangements to purchase the actual debt and calling it a sale of the, a transfer of the debt instead of calling it a sale. he tried to invite the court essentially to look into these proceedings and deem them a conspiracy as well as injurious to him. However, it was not well proven and it was actually not laid out in the pleadings as well. So points 3, 4, and 5 all failed, as Mr. Damianos was unable to prove those things. As such, in the end, it was ruled that Mr. Damianos was not entitled to the commission, as the transaction was outlined not to be a sale of property, but a sale of the mortgage, which was transferred in accordance with all the regular formalities, as well as Mr. Damianos was not able to substantiate his claims of tortious interference and conspiracy to interfere and injure him by the other defendants. So as such, Mr. Damianos was actually ordered to pay costs. Do note, as I said earlier, each of the defendants had their own attorney, so he had to pay legal costs of his attorney and all of this.
Yeah, he had, how many? He had to pay Luther McDonald, Sean Murray.
He paid plenty keys to.
Yeah, that's a lot of attorneys.
And cases, yeah.
No,
and his own attorney.
Enough. That's injury enough.
But you know, these real estate persons, when they list these properties, they're serious with that.
Yeah, Masacha, because he already had that money, accounted.
Yes.
No telling what other deals he made on the side, thinking he'd had that $400,000+ in his pocket.
Mm-hmm. And now come along now. They took it and then they transferred the property, and he's, as far as he's concerned, trying to rob him of his money. And he didn't like that.
That wasn't nice though. They should have gave him something out of him.
Listen here, this has nothing to do with niceties.
I know, right?
They did give him something. They just give him more trouble than what he looked for. He asked for something and he got something, and that's it. He got to pay somebody else. And nobody tell him to rear up his head. The courts even told him, listen, you fought well. You even fought well in the face of knowing you actually about to lose this thing, and you maintain this integrity, but nothing that he produced and nothing that he was ever able to evidence by his attorney, by anyone on his team, could outrightly prove anything in relation to his case that, okay, yeah, this was actually a sale of the property, he's due his commission. And there was nothing. Like, they really went to court and they just was hoping the court smile on them.
In their favor. And see, that Masacha, I really appreciate these cases, just simply because, the normal man or the regular man would not have gone in deep, not knowing that, hey, and in his case, I with him in terms of thinking that I could still get payment. Because they did list it with me. I did put it out there. And now the people decided this isn't going to do, but then somebody else took over the mortgage and blah, 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 rah, rah, rah. He still had hopes that he could get something out of the deal. And then there goes the court. And I always say it depends on who judge and see. Because if he looked desperate or injured enough, maybe that judge would have said, you're always wrong. The man did go, but then this judge says, no, this was just a transfer of mortgage, not so much the sale of the property. So I don't know, law is something else.
Yeah, but this is what you all say. So, like I say, the cases show you how it is interpreted when you go to court. Because a lot of people just look at the clauses, they see the provision, they sign and they go and they make the payments. And then when things go awry, they be trying to figure out what they can do. And you could notice from all of these, when the bank is exercising its power of sale, it has all rights by law. They will sell that house or that triplex.
Ms. Archer, I have a question for you. With is it a situation where the court has determined that the mortgagor was still the beneficial owner, and the transfer of mortgage means that the mortgagor remained in possession of the property, and the other person only took on the debt, sort of like how our Arawak Homes has a holding company where they bought out a lot of debt, so the customers would still own their property, but they took over the debt from the bank. Is that what happened in this case?
Mm-hmm.
Oh, okay.
The special vehicle was just set up for that.
Okay.
Yeah. These are just a structural change, but we realize it too. It's a point that you all didn't mention as yet. Notice how the persons who wanted to buy the property, did you notice that they were going below 50% of the value?
And that's why I think on our test you covered it as well, where the banks would try to, in where possible, to get the mortgagor to sell, because anytime someone here, the bank is selling a repossessed property, they think fire sale, and they underbid and trying to get it for the lowest amount possible.
Mm-hmm. Because they were trying to purchase this for half the value. And so that's why they came up with another arrangement, because don't forget now, everything is business. It's all about business and making money, and they didn't intend to lose that value. So it was better for them to restructure with another company, because he didn't want to lose it, with another company, and then they could still go out in the market and try to sell it. Okay, so let me do the last case for tonight. This case is First Caribbean and a lady called April Raquel Penn. So First Caribbean, FCIB, granted a loan to April in the amount of $150,850 at a rate of 9.5%. And that was to help her buy a piece of land, and she wanted to build a duplex. So she contracted with FCIB to pay them $1,317.97 monthly over 25 years until the loan was fully liquidated. So she failed to make the agreed payments, and she fell into arrears. So she had an outstanding balance of $187,594.26, and that was due and owing. The sum has increased now to $304,760.70 as of the 29th of January, 2020, and interest continues to accrue. So FCIB demanded the outstanding balance, but April has failed and or refused to settle or satisfy the outstanding amount. So what she did was she filed a defense on a counterclaim. And she is saying that she is not indebted to FCIB. She admitted that she signed the loan, but she alleges that the deed of mortgage was void or voidable because of certain things. One, the total failure of consideration. Two, mistake or frustration. She also alleged that if any sum was outstanding, because she wasn't admitting to the liability for the outstanding sum of $304,000. She said the same was due to FCIB's negligence She also alleged that under the commitment letter, it was the duty of FCIB to render good and marketable title, and that the law firm that was involved in providing a title opinion and drafting the mortgage deed represented FCIB and not her. Therefore, FCIB should have sued the law firm and not her. You understand April's point?
I get lost right there. I don't know why she
FCIB, sorry. FCIB was selling her the property?
No, she went to FCIB for a mortgage.
with a mortgage.
Yeah, that's
right.
what I'm saying. So I'm saying if FCIB was selling her the property, you know, it's the purchaser's attorney who will prove to the buyer that, yeah.
But they were
the buyer's attorney, the seller's, sorry, attorney supposed to prove to the buyer's attorney that it had good and marketable title. No,
we can get there. We can get there. Hold on, we'll get there.
Because I want to know how she could blame them.
Well, best way on.
The bank chooses because the bank tells the customer who they could go to and who they can't. I think that's what she might be getting at.
There we go. Remember we mentioned this before in another case with the list of attorneys.
Yes.
Okay, all right. So let me see here. So she's claiming damages arising from a claim of frustration, misrepresentation, and defect of title. So her deed of mortgage was for lot number 20 in Bricknock subdivision in Carmichael Road. So I already told you how much she had to pay per month. I already told you what was outstanding. So the bank alleges that it notified April of her breach in a letter on the 4th of March, 2009. And they demanded that she pay all the sums due and owing under the loan. But April failed or refused to do so, and she still remains in breach. The bank is saying that the deed of mortgage dated the 5th of March, 2004, between the parties provided for April to secure a mortgage over the lot to the favor of the bank, and thereby the deed served as collateral for the loan. However, since the grant of the mortgage, the property was condemned and is useless for the purposes intended. You heard what I said? The property
Repeat it.
Okay, so the deed of the mortgage was dated the 5th of March, 2004, between April and FCIB over the lot. And the deed served as collateral for the loan. However, since the grant of the mortgage, the property was condemned and is useless for the purposes intended. You understand that now? She got a mortgage, but subsequent to that, the property was condemned and is useless.
So that sounds like that's a problem with the appraisal report, because when the attorneys give their opinion on title, one of the things that they specify is that it has nothing to do with the condition of the property itself and so forth. They always have that disclaimer in there, but I'm sure they got an appraisal prepared over that property.
But what if, Stacey, for argument's sake, what if when she did the mortgage, it was okay? And then something happened, like I said, like how we have now over the bridge, you know, they're not giving loans anymore for those properties over the bridge because Dorian happened. And so Dorian will always happen every year.
So the timeline we'll have to tell. We'll have to see what was the reason for when it was condemned, when that happened, and so forth, I guess.
Right,
right. All right. So let's see what happened next. The FCIB asserts that it has suffered loss and damage, and they claim the outstanding sums. So April, in her defense, she said since then she has amended her defense and her counterclaim. She amended her defense and counterclaim 5 times. So after seeking leave of the court to file another re-amended defense and counterclaim, she alleged fraud. And she relied on her last counterclaim with her attorney. So the gist of her amended defense is that she is not indebted to the bank. She admitted that she signed the loan, but alleged that the deed of mortgage was void or voidable due to, 1, failure of consideration, mistake, or frustration. April also alleges that if any sum was outstanding, it was due to the bank's negligence. She said that it was an express term of the loan that the monthly premium would be paid regularly until the loan is liquidated. The bank or its servants or agents, in unlawfully neglecting to withdraw payments from a salary lodged at its bank, has caused the said payments to fall into arrears, thereby causing the said agreement to become frustrated. So she's saying that the money was in the bank just didn't take out the money. So they're the reason why she's in arrest.
Sacha, hold up.
She sounded like she lost her mind.
I swear, because she must have mean it was deducted out of the salary and she gone to the ATM and take it.
Well, she
It's
must
the bank fault that they didn't take it in time.
Yeah, like I did a salary deduction, but they wasn't taking it.
Right. So I take it, but they suppose that's their responsibility to take it.
Yeah, they at fault. She lost her mind. I think she needed a reevaluation.
So she says, listen now, she asserted that at all material times, she was a local investor wanting to build a duplex for her use as her residence with a second apartment for rental income. The project was funded by a mortgage construction loan from FCIB. She also asserted that the bank was negligent in releasing funds without checking to ensure that the building was being constructed properly, or without checking to ensure that the land was properly suited for that purpose. She says she ceased to make payments on the loan upon becoming aware that the property was found unsuitable and eventually condemned by the authorities.
So that was swampland or something, eh?
Wait. She alleged that the building works was substandard and the partially completed structure collapsed into a sinkhole caused by covered debris beneath the foundation. You heard that?
Mm-hmm. That's swampland, eh?
No, that was sinkhole.
Sinkhole.
Sometimes it's a cave. Sometimes, the land have caves.
Mm-hmm.
Mm-hmm.
Yeah,
okay, so that's understandable.
So it was
that's our property.
Yes. So it was later discovered that the property, the security, had been conveyed previously 2 times to 2 separate parties prior to it being sold by the same vendor to her.
Jesus.
She's also crazy, dog.
Jesus.
So title to the property was not good and marketable.
No, it wasn't.
Wow.
Right, that man ain't do his too, or the lawyer.
Yeah, but somebody dropped the ball.
Neither party could ever have good title. So April says that the bank had a list of approved attorneys that she was invited to choose from for the purpose of rendering a title opinion to the bank as a prerequisite to the loan. The attorneys for the bank had certified that title was good and marketable for the purpose of the mortgage to her. Consequently, the mortgage failed to be proper security. The bank is in breach of the contract to her by way of the commitment letter from the bank to her wherein her obligations as borrower, mortgagor were premised firstly on her obtaining good and marketable title. Relying on the title opinion provided to them, the bank disbursed the loan in various stages. Firstly to the vendor for the balance of the property purchase price, and then to her contractors at various stages of completion of building works as certified by the bank's evaluators. April made interest-only payments during the construction, and she did that pursuant to the commitment letter. Within months of the loan, it was discovered that the property was unsuitable and that the land had to be, quote, backfilled and packed, end quote, to support the foundation.
Wow.
So she said after the commencement of this action, in 2016, it was discovered that the property had been conveyed 2 times, like she said. And these earlier conveyances were on record, and the attorneys for the bank ought to have seen them and should have advised that there was no title to convey to her.
Yep.
And she counterclaimed for the return of personal monies she injected into the project above and beyond the loan in the amount of $30,000 plus. And then she asked for damages for her loss of rental income, her peaceful enjoyment, costs, and anything else. So what did the bank have to say? So the bank denied that it refused to accept or to apply payments to April's loan. The bank denied that the agreement was fraudulent as alleged by April. The bank denied that it was negligent and alleged that it owed no duty to April, whether it was contractual or otherwise, to determine if there were defects of the property. The bank said that at all material times, it acted on the title opinion of McKinney, Bancroft, and Hughes, which led it to disburse the loan proceeds to April and accept the property as security thereto. FCIB also said that April selected the firm arising from her employment, and it would not have been proceeded to issue the sums under the facility agreement had it not been for its receipt of a title opinion from the firm indicating that title to the property was good and marketable. FCIB also said that once Ms. Penn identified an attorney to act for her, the bank issued instructions to that attorney to investigate the title and prepare the standard loan documents. So the bank say in a nutshell, April, prove it. So the judge said the agreed facts was, yes, there was a mortgage. The principal was this, the interest was that. She went there to purchase the lot and the bill of duplex. There was a commitment letter. Then she notified the bank of the breach. So the bank said, so the court says, now let's go to the evidence. The bank called 2 evidence, 2 witnesses to give evidence, a Mr. McDonald and a Miss Sharice Archer. So all the witnesses were extensively cross-examined. The judge said I had an opportunity to see, hear, and observe them as they testified. On the balance of probabilities, I prefer the evidence of the witnesses for the bank. I found both Mr. McDonald and Ms. Archer to be honest witnesses, and I accepted their testimony that April and not the bank was the one that chose the firm. I did not believe April that she was not given a list of attorneys to choose from, and the bank chose the firm. She insisted that the firm was the attorneys for the bank. So if that is true, who then was her attorney? She was the purchaser of real property, and it is standard practice that the bank has a list of attorneys for prospective purchasers to choose from. She chose the firm because she was an employee with them, and she stood to benefit by not paying legal fees. On top of that, every stamp and recording fees were not paid in one go, but deducted from her salary. If I understood her well, at one point, she stated that the firm acted for both parties. If that is the case, then the firm also owes her duty in the preparation of the title opinion and the mortgage deed. So the court said there are 4 issues to be answered. Whether April breached the terms of the commitment letter and the mortgage facility by failing to make her payments. Whether April breached the terms of a commitment letter and mortgage facility by failing to keep monies in her savings account so that the bank could deduct her payments. Third, whether the construction and the degree of the obligation created by the covenants under the commitment letter gave rise to a duty to FCIB to give good and marketable title. And whether the dispute over the title being good and marketable gave unto April the right to breach the facility with the bank. And fifth, whether the dispute over the suitability of the land gave April a right to breach the facility with the bank. Because remember, she said that because the land was not suitable anymore, then she didn't have to pay. So the court said, looking at issues number 1 and 2, whether April breached the terms of her commitment letter and mortgage facility by failing to make the payments and not keeping monies in her account. So the court said that the commitment letter was signed by both parties on March 2004, and the regular payments was $1,317.97. It was an express term of the loan that she would pay until the loan was fully liquidated. So her last payment was on May 9th, 2004. And the court said that April's evidence is clear that she ceased payments under the loan and the loan fell into arrears. During cross-examination, she stated that monies were coming out of my account where my salaries went, and the payments initially ceased when I was no longer employed. I didn't have a job. When she got a job at Plus Center at Town Center Mall, she continued payments until I wasn't able to anymore. That was sometime in 2007 when I spoke with the bank, and the manager at the time had agreed that they would try to sell the property, and that's where we was. She could not recall whether she resumed payment after 2007, but this is not material, as the parties agreed that her last payment in sum of $217.25 was made on the 9th of May, 2007. So, in brief, April breached the terms of the commitment letter and the mortgage facility by failing to make payments and failing to keep money in the account to service her loan. So under issue 3, whether the construction and the degree of the obligation created by the covenants in the commitment letter gave rise to a duty on behalf of FCIB to render good and marketable title. So April contended that the covenants in the commitment letter gave rise to a duty on behalf of FCIB to render good and marketable title. The bank argued that the covenants in the commitment letter are general and unambiguous terms governing the loan. And then they went through the commitment letter, which stated that in the covenant, the mortgage is of course to be in the name of April Penn. Title in all matters pertaining to the mortgage loan will be in a form satisfactory to the bank's attorneys at law. The legal work for the preparation and completion of the mortgage will be done on the bank's behalf by its attorneys at law. Mr. Cambridge, remember, he gave evidence on behalf of the bank, submitted that these covenants were prerequisite fundamental contract obligations against the bank that had to be performed and that had to remain in effect before the borrower could become eligible to issue the mortgage to the bank, or for the mortgage to remain good loan security. Mr. Cambridge further submitted that the bank breached these fundamental contract terms from the inception of the mortgage relationship. And ideally, it should be suing their attorney, the firm, for issuing an incorrect title opinion that it relied upon in granting the loan and accepting the mortgage as the loan security. According to him, I forget, Mr. Cambridge is her attorney. According to him, April is the resultant victim of damage and loss resulting from contractual events to which she was not privy. Now, under clause 3 of the mortgage deed, it spoke about charge. It says the mortgagor as beneficial owner hereby grants and conveys and assigns unto the bank all that the mortgage premises as a continuing security to the bank, with the payment of all money covenant to be paid by the mortgagor under this indenture, to hold the same unto the use of the bank in fee simple and absolutely subject to the encumbrances and to the proviso for redemption hereinafter contained. Clause 12 also provides a discharge of the charge. If the mortgagor should pay to the bank all the secured sums, the bank at any time thereafter, at the request and cost of the mortgagor, will reconvey or reassign the mortgage premises to the mortgagor or as the mortgagor shall direct. So according to her lawyer, they said that these covenants could not crystallize because she didn't have good title, and said that April had no title to secure the bank with. And secondly, the bank could not reconvey or release a title back to April once the loan was satisfied, because remember, the property was condemned. So really, his argument was that April could not receive any benefit from this arrangement, this whole mortgage, because she didn't have good title. So he going on and he asserted that the title opinion was grossly inaccurate as the defects were discovered after the funds were disbursed. He argued that the defects were of a nature whereby they ought to have been detected by the firm beforehand. Consequently, all contractual arrangements between FCIB and April became fully frustrated, and April had a duty to mitigate her losses by ceasing any further personal investments in the construction and to suspend paying the loan. What are your thoughts now? You think she's correct based on the advice from her lawyer?
I think she's correct. I think that she was correct in what she did. And I think that the bank, as usual, has the wrong person in court. It's always the little man, but when they put the attorneys on their list, the part of the requirement is that they show proof that they have professional indemnity insurance for this very reason. If there's any, if anything goes wrong with their report on title, that they could sue them. And even with the property having the sinkhole, the appraisers are also supposed to have indemnity insurance that if whatever they have in their appraisal report is erroneous, they can also pursue them. But they always end up putting the little man in court.
That's what you call them, the little man?
So the regular mortgagor, the people who really can't afford it, why sue her right off the bat as opposed to going to McKinney Bancroft for giving them faulty title that they did advances against? That's something wrong
there. Okay, let me go on now before I send you home to ponder some more and drink some tea. The evidence, as I found it, demonstrate that April was employed at the firm at the time of the loan, and she selected the firm to prepare the title deeds and to investigate title. In her evidence, April stated that she did not have to pay legal fees incurred because she was a staff at the firm. In addition, she did not have to pay stamp fees and recording fees at the inception as the firm paid it, and it was subsequently deducted from her salary. So although April tried to suggest she did not select the firm to be her attorney, I find that she did. There were obvious prerequisites to be derived by selecting the firm, namely, 1, she didn't have to pay legal fees, and 2, she did not advance the stamping and recording fees as it was taken out of her monthly salary. So the finding is bolstered in the second supplemental witness statement of Mr. McDonald, where he stated that April selected the firm and the bank sent the instructions to the firm in a letter dated March 2004, signed by its personal banking representative, Gia Williams, to the attention of Mr. Campbell Clare, the third of the firm. The letter states in part, quote, "No doubt you will provide us with the certificate of title in due course. Further to this, we also request that you will provide us with copies of the mortgage documents for our files once they have been executed by April Penn, until the originals are returned from the registry for recording and stamping." I agree with Mr. Rigby, and Mr. Rigby represented FCIB, that there are no words in the letter to reasonably infer that FCIB agreed to assume any responsibility or duty to the preparation of the title deeds or the investigation of title. Mr. McDonald, who withstood the rigors of cross-examination, also confirmed the bank's practice in the selection of the attorney. He stated that the, quote, "attorneys acts for and on behalf of the customer, primarily to ensure that the customer in any real estate transaction can ensure that the client is protected," end quote. In her evidence in chief, Ms. Archer also confirmed that Ms. Penn selected the firm to prepare the legal work. During cross-examination, Ms. Archer reiterated that April selected the attorney from the bank's approved listing of attorneys. The judge said, "I agree with Mr. Rigby, KC, that the commitment letter with the covenants must be construed to align with common sense and standard banking business and practices." So in this regard, he cited a couple cases. And in one of the cases, which is Constant Limited versus Tarmac Holdings, he said the judge in that case expressed the importance of applying common sense to agreements. And quote, this is the quote he put in the judgment. "The language used by the parties will often have more than one potential meaning. I would accept the submission made on behalf of the appellants that the exercise of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. In doing so, the court must have regard to all the relevant surrounding circumstances. If there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. Then he went on in another case called Arnold, and he summarized the principle as such. When interpreting a written contract, the court is concerned to identify the intention of the parties by reference to what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. That meaning has to be assessed in the light of 1, the natural and ordinary meaning of the clause, 2, any other relevant provisions of the lease, and 3, the overall purpose of the clause and the lease, and 4, the facts and circumstances known or assumed by the parties at the time that the document was executed, and 5, commercial common sense, and 6, but disregarding subjective evidence of any party's intention. So Mr. Rigby KC contended that the terms of the commitment letter are clear and that there are no terms in it that the mortgage, which can lead to a conclusion that the bank agreed to undertake a review of the title to the property, or that the bank had a duty to ensure that April was purchasing clear title to the property. According to Mr. Rigby Casey, the common sense approach is that the firm was selected and paid for the purpose of investigating title to the property, and therefore the firm alone owed a duty to April in respect of the same. Further, as the conveyance is in the name of April, she had the duty to ensure that she received what she bargained for in relation to the property. The commitment letter is clear. Reading the covenants, inelegantly drafted in the commitment letter, in conjunction with the letter that Gia Williams wrote to the firm on the same day, the bank granted her a loan of $150,850 to assist her with the purchase of land and construct a duplex. The evidence before the court does not suggest or intimate that the bank was a party to the identification of the property, or that it played any role in the title investigation of it to serve as collateral. What is clear is that April had already selected the lot by the time of the approval of the loan, as she signed the conveyance in February 2004, 1 month prior to the execution of the commitment letter. It is also true that Campbell Clare was the attorney who prepared the conveyance in February 2004. And therefore, a reasonable inference to be drawn is that April selected her attorney long before she approached the bank for financing. So the judge says, in my judgment, looking at all the documents, including the commitment letter and the mortgage deed, I find as a fact that the bank did not assume any larger role or duty towards April, and certainly did not agree to investigate title and to assume responsibility for clear title. The commitment letter sets out all of the salient terms which govern the relationship between the parties, and it accorded with the general practice and procedures of the bank and the traditional banker-customer relationship. So going to the fourth and fifth issue, where she said whether the dispute over title gave April a right to breach the contract, and whether the dispute over the suitability of the land gave April the right to breach the facility of the bank. So the court had examined her, and they said, on the clear and unequivocal provisions of the commitment letter, it is correct for this court to find that the intentions of both parties were limited to the bank contracting to advance the amount borrowed and April contracting to pay the loan. The duty to investigate title to the lot to serve as collateral resides with April and her lawyers. As I see it, April selected the firm for the purpose of investigating title to the property, and the firm alone owed a duty to April. The failure of April to continue to pay the loan was a breach of the agreement, and any dispute as to defects of title ought to have been directed at the firm and not the bank. The court also said there was no frustration in the facility agreement and there was no mistake. So he said in conclusion, the simple facts of this case is this: April wanted to purchase the lot to build a duplex. She was working at the firm. There are some prerequisites involved in using the firm as her attorney. The primary one being that she did not have to pay legal fees. The mortgage was prepared by the firm in February 2004, a month before she signed the commitment letter. The firm had to provide the certificate of title in due course. After the loan was approved and drawn down, it was discovered Not only that the building works was substandard and the partially completed structure collapsed into a sinkhole caused by covered debris beneath the foundation, but that the title to the property was not good and marketable, as the security had been conveyed 2 times in 2 separate parties prior to it being sold by the same vendor to her. The title opinion provided by the firm was lacking. So although April vehemently denied that the firm, her previous employer, represented her, a rhetorical question can be posed. If the firm represented the bank, then who represented her? Was she purchasing real property without legal representation, or did she expect the bank or the bank's attorney to look out to protect her interest? The reasonable inference to be drawn from these facts is that 1, April selected the attorney. 2, the attorney, an employee of the firm, worked on her behalf and rendered the title opinion to the bank. And 3, the work carried out by the attorney was to be paid by April, but was gratis due to the fact that she was an employee at the firm. In my judgment, April breached the terms of the commitment letter, mortgage deed, and consequently, FCIB is entitled to recover the sums due and owing under the mortgage. For all of these reasons, there will be judgment for FCIB in the amount of $321,092.62 as of the 20th of May, 2021, with interest accruing starting from the 31st of January, 2023 at a rate of 6.25%. And the bank is the successful party in this action, and Ms. Penn must pay the cost to the bank. But as this is an unfortunate case, the judge said, I will make an order that each party bear their own cause. Signed by Senior Judge Indira Childs.
My Lord. Ms. Archer, what was the price of the property in its original state? The mortgage, sorry.
She got a loan in the amount of $150,850 at a rate of 9.5%.
And now she got to pay back $300,000 at a rate of 6%.
Yeah.
Good Lord. Also, you know what is so, I wouldn't say unfortunate. She worked with the firm, and because she was not going to, it would have waived their legal fees or whatever, the cost of stamp tax or whatever, which was not really the firm's responsibility to pay. So I guess those were her only fees.
They took that out of her salary.
Yeah. The thing is that she then wanted the bank to be at fault, but
Michelle, you gone.
Oh God, I tired of this internet.
You're back.
Okay. So she wanted the bank then to try and sell the property to somebody else. A property that...
No, the property was condemned.
The property was condemned, but I think I heard you said that she wanted to be able to sell the property to somebody else.
She can't sell that. That's a sinkhole.
Exactly. So the thing is, what I want to know is...
You got to pay that mortgage, though.
Yes, the responsibility is hers to pay because she bought the property.
Yeah,
that's her property. And she bring the property to the bank to have the her thing built on, but that's still her property.
Yeah, she could make it a tourist attraction.
In addition, Ms. Archer, what happened? And this is outside of it. What happened to town planning, giving her even the right to start construction on such a property?
Well, seeing that she got her funds on the side, she probably did that on the side too.
My Lord.
You can't cut corners. You have to tick every box. You could see that now from getting a mortgage.
Exactly.
There's so much things that could go wrong. so many things.
Wow. And then having that property twice over.
Yeah. Mm-hmm. That's more than twice.
She still work for McKinney.
No, she doesn't.
Wouldn't either.
No, she doesn't. Don't forget, she went to work for Furniture Plus.
Wow.
At the Plus Center. And then she stopped paying in 2007. Her last payment was only $217. I don't know why they dismissed her from McKinney, but she was dismissed, so she couldn't pay this mortgage of $1,300 a month.
She probably was cussing them so bad. That's why.
So
she was cussing them.
But like Rigby said, she really should have sued
the attorneys.
Yes, that's what she should have, but she didn't.
I always tell people, don't stop paying. Don't stop paying. Continue to pay by the cost.
Yes. So if you lose, you don't have to pay that much.
Exactly.
Yes.
Oh, Lord. Unfortunate.
It is very unfortunate. Very unfortunate. But the good news is next week class will not be that long because it's on due diligence. I don't know if I can find any case. I'll see. May have to be a UK one. I don't think I could find a Bahamian one. To do with mortgage, customer due diligence. Yeah, so thank God you'll have a short class, but I think I do have a case on subdivisions. The leading one where
Arawak Homes.
Arawak Homes. No, it is not. No, it is not. The one that went to the Privy Council.
Okay.
No. What's with y'all in Arawak Homes? Leave the people alone.
What's with Arawak Homes?
Arawak Homes got their order for all of their properties. Don't go and build on the people's property. They will.
God. They coming for you. You gotta know that one. They coming.
They coming. All right. So no questions. Good. Zenobia, what happened?
A question, please. It may not be related, but I noticed like now. You can hear me? Can you hear me? You can hear me, Ms. Archer?
Yeah, I can hear you.
Okay, one of my questions is I'm noticing like a lot of banks, they're putting in these clauses where you cannot prepay a mortgage, right? So once you sign that agreement, because I know they could demand their mortgage, right? But they want, sometimes they don't allow you to prepay it at all, even if you give them notice, right? So I'm just wondering if the agreement letter takes precedence and, you know, like why you can't just pay them back as long as you give them their money. I know they have their interest and everything allocated, but shouldn't there be some sort of clause that allowed a client to, you know, pay you your money back just how you could demand all your money at one time? Let's say the client get an insurance, someone dies, leave insurance money, right? You just want to take the insurance money and put on the mortgage, but then there's a penalty for it. I'm just wondering if
I just want to say they allow you to pay. They allow you to pay, but you got to pay to play.
Yes.
You don't want to lose that interest.
They're not going to lose that interest. So, like she's saying, they could say, you can make 4 principal payments a month, or they're going to have to calculate how much they're going to lose, and that's going to be a penalty that you pay.
I think there was a case. There was a case where the bank would have laid out, you know, if you want to pay so much percentage of the outstanding principal, then there's a fee. Then if you want to pay 85%, then there's a fee.
Because we're just not the present value, but the future value of that. So you can't go changing the terms of the contract.
Understood, but I was just thinking, you know, I mean, the objective is you want your money. So if I have a lump sum of money that I can give you, then let me hurry pay you off.
No,
No, the objective is to make money from you.
Yeah.
That's the objective. So let's get this thing twisted.
Oh, God,
You
I'm
can pay
so
me my
sad.
money. You can pay me my money nonetheless, but I want interest.
You see, she have to remember, she has to think like a businessman.
All right.
It's all about the money.
Yeah, understood. I just wanted to know.
All about the money. Okay, so before we briefly go through customer due diligence next class, we still have David to do. David Chardon.
Yes, I'll be ready for that.
Okay.
At least I'm ready, but time is up.
Are you ready now?
Yeah.
But time up though. Ask the class. Class, you want to hear it?
I mean, if they want to hear it, it's similar to a case we had before.
Yeah, I ain't hearing nothing.
I don't have a problem with it.
I don't have a problem. It's interesting.
Next week, if they don't want to, I mean, it's up to them.
No, they say they don't have a problem. Go ahead.
Oh, okay. So it's similar to a case we had before. I don't remember the name of it. It has to do with life insurance as a security as well. And it's the case of David Chardon, Christopher Chardon. Pardon me?
No, I say your internet going in and
Christopher
out.
Chardon is executing the case of David Chardon and fix it. But I said Christopher Chardon, he is the personal representative in the state of David. Estate of the late Christopher. Yeah, David Chardon is the personal representative in the estate of Christopher Chardon versus First Caribbean Bank. And apparently the respondent, First Caribbean Bank, is asserting that the respondent's predecessor, Barclays Bank, assumed the responsibility for ensuring the life insurance policy issued by Global Life Assurance through Barclays Finance was affected. So in this case, they're basically saying that some subsidiary of Barclays Bank was responsible for providing insurance for the now deceased. And they also said that David signed, similar to a case we had before, he signed the assignment forms. And of course, everything wasn't completed relative to that. It's also saying that first, the insurance broker is an independent entity. So it's showing that the insurance broker, while it may have been attached to Barclays, it still functions as a separate entity. So it's an independent entity, and it says second, the relationship between Barclays and the insurance broker, Barfinco, are parent and subsidiary. So the parent and subsidiary relationship express that they are distinct legal entities and not principal and agent in the absence of an agency agreement. Lastly, it's saying that the appellants basically failed to prove in their case the standard required balance probabilities at the end of the day. So like I said, this is similar to a case we had before. Only thing, this is a parent subsidiary case where they're trying to determine whose responsibility it actually is to ensure a life insurance is carried out over someone prior to their death. And so of course, this person, obviously he signed the assignment forms, he passed, and of course the same background facts where you know, the mortgage depended on it. That was one of the collateral securities. The insurance was one of the collateral security documents required. Of course, the bank drew down the funds. The gentleman died, no insurance. So now everyone wants to claim, and it goes back. The ruling goes back basically to one that we would have had.
You going again?
Where
so Novia
you
must
know, the
have the
court
same
ruled in
internet
favor
carrier.
of the bank because it also placed the responsibility on the borrower to ensure that the necessary BTC, right? Yeah, I'll do it next week then. I'll do it next week, Ms. Thatcher.
Okay, yeah,
BTC, BTC.
BTC, yeah, that's BTC. So yeah, I'll do it next week. That's fine.
Okay, yeah, because it'll be clearer.
Okay, all right.
Okay.
All right. Good
All
night.
right.
Thank you. Okay, bye.
Good night.
Good night.
All right. So you had a good class. Next week.
Good night.
Good night.
All right,
Good
good
night.
night, everyone.
Good
Okay,
night.
good night.
Good
I
night,
don't-
everybody.
I'm so
Night.
sad as you all are leaving. I gotta find a case to make you all happy.
Good
Bye.
night. Good night.
Good night.
All right, good night.
Leave.
Hi, Miss Archer. Before you leave,
Yeah. Mm-hmm.
okay, just wanted to know, I had requested the questionnaire from Miguel. He was supposed to send it again this afternoon. I called him, but I still haven't gotten it for the last exam.
Oh, okay. Okay, I'll remind him. I'll send him a WhatsApp message.
Okay.
Yeah, I'll do that.
All
All
right. I
right.
just wanted to know like what I missed or where I went wrong
Mm-hmm.
with the questions that I got wrong.
Okay, all right. I can remind him right now.
Thank you.
Okay, not a
Okay,
problem.
have a good night.
Okay, you too.
Thanks.
Okay.